With what? With basically two rights. In a remote manner, a fundamental right, but basically the rights touched upon were property rights. The three cases brought before the Supreme Court were brought by landlords. I am not ridiculing them, but I want this because it's a very significant factor. All the three times that the amendment by Parliament was challenged was not challenged on the ground on which he would like to challenge it. It was never challenged on the ground that the freedom to speak, the freedom to propagate, the freedom to disagree. He didn't elaborate it. I regard the freedom to disagree, to dissent, far more important than even to speak ordinarily. And the freedom to disagree with the laws and the powers of the day is the basic freedom. Our Constitution has it. Has it ever been touched? Has it been tampered with? Has it been compromised? I would like to know, can we go on building a case on the hypothesis of fear that in the past Parliament has flippantly tried to tamper? No, sir. Fundamental rights have not been touched. Once only they were guarded. He referred to the example of Gerard. There are people who claim Gerard as a fundamental right in furtherance of the legitimate rights of the proletariat against the exploiting capitalists. Now what will you say? To that our reply is, there is no such fundamental right as a right to get out. That, I think, will be the voice of the majority of the Indian people. Not the penal code, but a far more sanction that the right to get out is a negation of legitimate trade union activity, interference with the expression of the legitimate grievances of our working class, and therefore this right is against the very spirit of the Constitution. Therefore there is no right to get out. But it was claimed as a fundamental right by the Labour Minister of Bengal and by a certain school of persuasion. I am just saying the danger of those things. We now, having seen that there is enough authority in the world, that the Constitution should be amended, we come to the fundamental. I am submitting in the first place, there has not been a light-hearted tampering with the fundamental rights given to you by our Constitution. It has been only property rights. Why did it become necessary? I don't want to go. I do not want to raise your ideological call. But look at the scheme of our Constitution. It's an integrated Constitution. Part 4 and Part 3 are to be read together. Part 4 is the directive principles of the state, that the state shall ensure to every Indian the right to work. The state shall ensure to every Indian the right to get the reward of his labor and his state. The state shall ensure that men and women shall be treated equally. Now these are principles. Are they remain shibboleth? Or are they to be reflected in the daily life of every Indian? Is it just to be a document to be quoted in the court? Or is it something to be the part and parcel, to be owned with the fabric of life of an average Indian? A Constitution doesn't survive by what we say about it, either in the courts or in Parliament, but ultimately a Constitution in any real democracy survives to the extent that Constitution becomes the living faith of the majority of the people of a given country. This is the most vital thing about preserving liberty. He said that Hitler amended the Constitution bit by bit. This was the only slight historical inaccuracy he made. Hitler swallowed the basis of the Weimar Republic in one single act. It is called the Enabling Act. Under this act, there was no bit by bit tampering with it. Hitler didn't believe in such bit by thing, step by step. It would have been like, the Fabians. Hitler didn't believe in this gradual process. The inevitability of gradualness was Spencer's dictum for mankind and the British socialists. Hitler believed everything must be done at one single stroke. And by one single act called the Enabling Act, he emasculated the Weimar Republic. He therefore was not trying, this name of Hitler to be brought is a little dangerous thing. Because, it's likely to mislead you. And so if the product of Nazi bill is to be Hitler, we are against that bill. Now I am going to tell you the product will be something quite different from Hitler. How will you now say? Having said that fundamental rights, should they be amended? Which have been amended? Now I am going to say, may I assure you in the first place, there is no bill in Parliament to amend fundamental rights. What is the bill? The bill is a declaratory bill. What does it declare? It declares the competence of Parliament. Exactly whose competence? He says, Parliament has not the right. I submit to you something which then we will be taking to a culmination. In the first place, have the judges the right to amend the Constitution? I think there will be one reply, no. May I here quote a great judge? I think even Professor Palkhivala will not disagree with me in showing the respect he which I am going to show. Francis Bacon, in his monumental work on law, has this to say: Cum residatur alitex, judex transis in legis loterum, a judge who will transgress the legitimate will given to him and encroach on the field of legislation is violating his basic duty. I submit that their lordship of the Supreme Court precisely were guilty of this. This language may sound harsh, but I am saying it in all humility and with all due respect due to their lordships of the Supreme Court, the majority, not 6 as it was told, another little inaccuracy. There were 5 judges on one side, 5 on another side, and one judge wrote a separate judgment, disagreeing with the 5 in many cases, agreeing with them in some cases. That is Justice Hidayatullah. But let us say for the purpose, I think this is the exact statement. But basically he agreed regarding Parliament's competence with these 5 headed by Justice Subbarao. I submit to you that the Supreme Court has tried to amend the Constitution of India. How? Till 25th of February 1967, the Supreme Court in 2 previous judgments told us that Parliament has the right. And that Article 13(2) of the Constitution is not a bar to Parliament's competence to amend the Constitution, including fundamental rights. This who said? Not irresponsible MPs, eager to subordinate nation's long-term interest to the expediency of the hour and playing with the basic document called Constitution. This was the judgment given by the Supreme Court itself. What did it say? I want now to bring to you this point. Professor Palkhivala submitted to you that under Article 13(2), there is a permanent bar to Parliament amending the fundamental rights in Section 3 of the Constitution. Ladies and gentlemen, I submit to you, the Supreme Court in previous 2 judgments has held very categorically that the word law in Section 3, Article 13(2) does not mean an amendment of the Constitution of India. And there they have quoted Lord Dicey, who has said, constituent law is different from ordinary law of a country, and the Parliament's power to make these changes is absolute. This has been said by the Supreme Court. This was reiterated by the Supreme Court again in another case. Now let us see what happens. What should be the Constitution of India? It used to be said about the Court of Equity in England that equity changes according to the length of the shoe of the Lord Chancellor of England. You couldn't define equity, it depended upon the particular Lord Chancellor who was there. Must it happen to the Constitution of India? What your rights are, what my rights are, will depend on whom? On who happens to be at the particular time in history to be the Chief Justice of the Supreme Court of India. If it is Justice Patanjali Shastri, Parliament has the right to amend fundamental rights. If it is Justice Kania, Parliament has the right. But if it is Justice Subbarao, Parliament hasn't the right. But if it becomes tomorrow, if it is Justice Vanchu as is today, we have the right. Because Justice Vanchu has written the minority judgment of 5 judges in Golaknath's famous case. Now, so what is the Constitution of India? Not what the Constitution makers have said, not what the commentators have said, not what the Supreme Court has said, but who happens to be the judge.